Well, I'm delighted to introduce our speaker for this afternoon, who is Scott Pettitt, who, I don't know if that's the right pronunciation.
It is.
Okay.
Yeah.
Scott works for the South West Heritage Trust, which in 2014 took over the responsibilities previously carried out by Somerset County Council for archives, local studies, museums, and so on. He was appointed Somerset Manorial Documents Register Archivist in 2013 and is now going to talk to us about this project. Scott.
Thank you very much. Can everybody hear me? Yes, excellent. Well, it's a particular pleasure to talk to people with an interest in family history, because of course so often people assume manorial records are for academics. They're all in Latin, and that's not true either. And so often family historians pass them by. So, for example, Mark Herber's great ancestral trails, one of the seminal works on family history, devotes, a mere chapter to manorial records. And I think they're too often passed over. People assume they're impossible to read, difficult to access, etc. So today I hope you'll all leave feeling persuaded that manorial records are something for family historians, and that those people who've got a particular interest in names and individuals as opposed to economic or social or local history, manorial records are for you, and they're an incredibly valuable resource. So yes, Liz has sort of outlined the whole purpose of the Manorial Documents Register this morning. In the course of my talk, I will probably recap the odd thing that she has said, but I think generally we'll be covering different territory, and I'll be focusing in particular on manorial records that I've encountered in my work in Somerset, where I was project archivist on the Somerset Manorial Documents Register from June 2013 till December last year, and then in Devon, where I began work in 2015, at the beginning of this year, doing the same work for Devon, and that will continue until the end of next year. And of course the Somerset Manorial Documents Register is already available on the MDR website that Liz will have discussed with you this morning. And the Devon Register will, all being well, available, I would think, probably mid-2017, hopefully, assuming everything goes well. Something like that. Maybe we shouldn't count our chickens before they hatch, but everything seems to be under control at the moment anyway. The other thing to say is, I haven't prepared a presentation, but I have created a handout, which I'll be emailing to Rod, and hopefully he can circulate that to those of you who are here and those of you who are interested in it. So there's no real need to write anything down. Anything that I say today will be in written form in one way or another, so you can access it. So let me quickly just go through sort of the basics of what we're talking about when we discuss manors. Now, I'm sure a lot of you have seen the term manor used in all sorts of contexts. It's applied to houses, impressive country residences, estates, farms. It's a great form of aggrandizement, and particularly in the 19th and 20th centuries, you would find people call their house a manor. It's a sign of gentility, upward mobility, call your nice suburban home a manor. It makes it sound that bit posher. Unfortunately, the MDR has a rather narrower perception of what a manor is, and we follow the definition devised by Paul Harvey, who's sort of the doyen of manorial historians, and he defines it, a manor, as a piece of landed property with tenants over whom the landlord exercised rights of jurisdiction in a private court. And certainly by the 16th century, that was how most people in England and in Wales understood what they understood a manor to be. Now, when we talk about manors, it's important to remember that they varied enormously in size. A single manor might have included several parishes. Paradoxically, one parish might have contained several manors, or at least parts of them. So, for example, the parish of Brompton Ralph in Somerset had 4 manors. Charlton Adam, another Somerset parish, had 3. When we talk about the origins of the manorial system, really there's a lot of guesswork involved. The origins are rather mysterious. Like a lot of things, they were created by the Normans. And certainly by the time of the Domesday Survey in 1086, all of England is divided into manors, and those parts of areas within the country that don't have manorial jurisdiction are specifically identified as such in Domesday. So that's how entrenched the manorial system had become 20 years after the Norman conquest. However, the Normans hadn't brought the manorial system over wholesale, because there's nothing quite like it in France either. And yet there was nothing quite like it in England before the Normans arrived. So you've got a sort of hybrid system of something that was here already, and the Normans brought something else in, and it was all sort of mixed up together, and that's about as much as we know. And there are definite aspects of the Saxon system, Saxon legal jurisdiction in the manorial system, and I'll come on to that in a moment, some examples of that. Now, land in a manor fell into two types. Firstly, you've got the demesne land. That's the land that's farmed directly on behalf of the lord of the manor as a home farm. Then you've got tenant land, and that's land that's granted out to tenants who farm it on their own behalf, and they pay rents and services to the lord in return for their use of that land. And in the Middle Ages, tenants fell into two broad classes. You've got the freeholders, and then you've got those who hold land by bond or unfree tenures. They're known as villeins in the Middle Ages. They're essentially semi-slaves, and they have to perform services to the lord in return to holding that land. He owns the land that they farm, and he essentially owns them as well, really. Villeins generally gradually evolved into copyholders. And copyhold is an absolutely crucial term, as I'm sure you know from Lizzie's talk this morning. I can't emphasise enough how crucial copyhold is to the manorial system. So copyholders, they're not like villeins. They are essentially, they are free agents, but at the same time, they can't do as they wish with their land automatically. To change hands, copyhold land has to be surrendered into the hands of the lord of the manor, or more usually his steward, at the manor court, and then the next tenant is admitted. And this procedure was written down in the court roll, and the tenant was then given a copy of the relevant entry as proof of his tenure, and that's how you get the term copyhold. You've got the copy of the extract from the court roll, and that's yours. That's your proof that you're the tenant, and you hold that copyhold land. And of course, those copyhold documents, they're known as admissions and surrenders, and they will give details of the property, how long your tenure is to be, how much you paid for that tenure, etc. And they're absolutely fascinating documents, and they survive in huge numbers often, and they're often just described as miscellaneous deeds, and you'll find them bundled up in old boxes with leases and all kinds of things. But yeah, incredibly informative documents, particularly for family historians. On the entry of a new copyholder, the lord received a financial payment called an entry fine, and he also received a financial payment when a copyholder died. This was known as a heriot, and it traditionally took the form of the tenant's best beast. Now, by the 18th century, that custom tended to have altered, and rather than giving your cow or your horse or whatever, it tended to be a financial payment. However, there is always a danger in generalising when it comes to manorial records, because even in the 19th century, there were still cases where it was actually the best beast that was being paid when someone died rather than money. So, for example, I came across some correspondence recently from 1845 referring to a payment to the lord of the manor of Itten in Devon. It's in the parish of South Taunton, by the executors of one William Hellier to the lord of the manor there of William Hellier's best horse as payment following his death, because he held a copyhold tenement in the manor of Itten. There are other types of tenants as well. You've got leaseholders and tenants at will. And whatever type of tenant you are, you're expected to attend the manor court. Now we come to the court system. In theory, there are two types of court, the court baron and the court leet. Now, often here we are in the 21st century, and we like to impose, retrospectively, a nice rational system onto anything that went before, because it helps us make sense of it. And certainly it is a very convenient way for understanding how the manor courts worked in terms of their jurisdiction. However, at the same time, I do wish to emphasise that often the functions of the court baron and the court leet were amalgamated. And frankly, quite often, when you look at manorial records, it's quite clear that the people holding the court weren't too fussed whether it was a court baron or a court leet, and didn't really understand the particular functions of a court baron or a court leet, or the differences between them. They just thought, we're holding a court. So you get some functions in there that are associated with the court baron, and some that are associated with the court leet. Nevertheless, I will treat these as separate sort of areas, because, as I say, it does make sense when it does enable us to make more sense of the system, I think. So the court baron is usually held every 3 weeks. And this is the court that oversees tenancy changes. That is the bread and butter work of a manor court, essentially, dealing with the copyhold tenements. It also makes sure that the tenants uphold the customs, that's to say the laws and rules of the manor, and that they pay their dues and perform their contractual services to the lord. Now, the services a tenant might be asked to perform varied greatly. Often it's tilling the land for a certain number of days of year and that kind of thing. However, a 1321 survey of the manor of East Coker, a type of survey known as an extent, lists the obligations that each copyhold tenant is expected to perform. And among those is one Matilda de Sinclair, who holds a place called the Fish Weir. So she's obviously got the weir on the river in East Coker. And in return for holding that land off the Lord, she's obliged to find for the Lord, I quote, one esquire, i.e. a knight, with all his outfits and in all armies for 40 days a year at her own expense. That's a fair amount. That's quite a responsibility for holding a weir at the end of the day. And you have to remember this is 1321. Edward II is at war with his barons at this time. It's a particularly volatile period in English history. So this service is actually very likely to be one that she'll be called upon to perform. Because, I mean, if it's a peaceful time, you think, oh, well, in theory I've got to pay for a night, but it's never going to happen. But, you know, in this particularly bloody period of English history, it's more than likely, actually, she's going to be called upon to pay these things. So, quite a responsibility for holding a weir. Just got to hope she caught lots of fish, really, haven't you? The court baron also dealt with personal actions brought by tenants, like debt recovery, complaints of trespass and things like that. Again, if you're a family historian and you find your ancestor in connection with something like that, you've really struck gold. This is the sort of information that puts real flesh and blood on the bones of our ancestors, you know. Rather than just becoming a name, suddenly they become real people. And I think, particularly the medieval manorial records, you do find all the sort of, that bawdy medieval world that you find evoked in Chaucer's Canterbury Tales, for example. Here you find the reality of it, and it's just as colourful as anything that Chaucer dreamt up, really. They'd had more mundane jobs to do at the court baron as well, though. They appointed manorial officials like the reeve and the bailiff, who collected the lord's dues, and other officials like the hayward. He was a person responsible for keeping the fences and enclosures on common land in repair. So now we come to the court leet, the other theoretical manor court. That's held once every 6 months. It's also known as the View of Frank Pledge. Now, you remember a few minutes ago I did make a comment about how elements of the Anglo-Saxon system found themselves sort of reimagined, shall we say, in the post-Norman world. And the View of Frank Pledge did have its origins before the Norman conquest. It was an Anglo-Saxon system of peacekeeping where groups of 10 men undertook to be responsible for one another's behaviour. So it's kind of community justice in the world before ASBOs, if you see what I mean, a millennium ago. And this deals with, the court leet deals with more serious offences. So it's also where family historians are likely to find the ultra-juicy stuff. This is where you get assault and affray, you know. John Smith smashed John Davis's nose in and threatened him with a sword and things like that. Now, the lord or the steward oversaw the court. It became far more typical, really, for the steward who oversees the day-to-day running of affairs on the manor to be overseeing the manor courts. Largely because, especially after 1500, what you tend to find is a lot of lords of the manor have gone up in the world. What you'll find is that many lords of manors were not particularly wealthy individuals originally. They were essentially important farmers at the end of the day. A gentleman farmer, I suppose, to use a sort of 19th century term. However, a lot of them went up in the world with time, and they left the area. They would move to their nice townhouse in Bath or in Bristol, became merchants. And often they became quite divorced from the affairs of the manor court and what was taking place there. And I've certainly found correspondence in the 19th century and in the 18th century where you would have a steward writing to the lord of the manor who lives, you know, a good 30, 40 miles away in Bath, saying, you know, is it all right if I hold a court? And the lord sort of writes back as if to say, why are you bothering me with this? You know, and goes, oh, yes, that's fine, just carry on with it. And they're not really taking much interest in the day-to-day affairs of the manor by the 18th century, a lot of them anyway. So it's the lord or the steward overseeing the court. But there's a jury made up of tenants which makes presentations, known as presentments, I'll come back to those in a moment, of alleged offences to the court and delivers verdicts. So even though we're talking about a system that's born in medieval feudalism, at the same time it's actually justice of the people, for the people, by the people, essentially. You know, what it comes down to is a group of people taking responsibility for their neighbours and passing judgment on their neighbours where they feel they've damaged, you know, made an infringement within the community and this sort of thing. So it's very much like the modern legal system. We can see that, you know, the continuity between our own modern jury system and this medieval system. They tended to hold the manor courts originally in a particular room within the manor house, and that was called the courtroom, for fairly obvious reasons, or they might just meet in the general hall of the manor. But as I say, increasingly after, say, the 17th century, when you find that the lord may no longer live in the area, where they may have sold the manor house but might still own the manor itself, because that's not necessarily the same thing. The building is one thing, the manor as a unit of jurisdiction is something else. So often you find that they've got to find somewhere else to hold their court. And frankly, it usually became the pub. That was the most obvious place in which to hold the court. So certainly in Devon in the 1820s, the number of courts that you find being held in pubs, I think that was probably pretty typical by then. So there's quite a well-known pub that's still in Honiton called the Golden Lion, which is fairly grand, and the Manor Court used to meet there. Although Birmingham City Council still met in a pub until the 1870s, so it's not that strange. Now, court proceedings were originally recorded on long sheets of parchment, and the records of several years were stitched together at the top and rolled together. And that's how you get the term court rolls. And these are what tell you everything that happened in the manor court. They're the key records for the proceedings of the courts. From the 16th century, court rolls began to be replaced by volumes. Now, I don't know if anyone has ever used manor court rolls. They can be terribly unwieldy. Some of them can be 10 metres long, even longer in some cases. So they're not the easy. Never mind the difficulty of reading them. I mean, just logistically, physically working your way down a roll, it's not very easy. So it's a great relief when you come to look at the later stuff, the sort of, you know, post-1550 material, which tends to be in a volume rather than on a roll, and you've just got a nice, convenient volume. So just the same as looking through, say, you know, Victorian admission registers or something like that, that sort of format, usually about A4 size, something like that. And obviously, because they're more recent, they tend to be in better condition than the rolls as well. Although, I have to say, a lot does come down to storage, but you find an awful lot of court rolls, even 14th century ones, even 13th century ones, actually. They're in absolutely beautiful condition. They really could have been drawn up yesterday. It's quite astonishing in some cases to see just how well preserved they are. An abundance of other records were generated by the manor courts as well. Now, I mentioned presentments earlier. These are particularly interesting for family historians because they were drawn up by the jury, usually before the court hearing, and each matter to be addressed by the court is outlined there. And each matter is introduced by a set phrase, which is, "We present that," and then you will get details of the alleged offence. Now, the offences can include all kinds of things. It might be Mr. X hasn't been thatching his cottage, so it's come into disrepair. Mr. B has trespassed on my land. It's all kinds of things. And from the 18th century, these tend to have survived in quite large numbers where you've got a decent collection of manorial records. They're usually quite easy to read as well, certainly no more difficult to read than contemporary parish registers from the time, and they tend to be in English as well. So I would say for family historians, they're probably among the most approachable manorial records to make use of, actually. So always wants to bear in mind presentments. I'd say they're pretty crucial. Other things that are great for family historians are lists of jurors serving on the manor court and tenants. And of course, in some cases, you can have whole runs of those extending across decades if you're lucky. So what a great resource in the days before census returns, and particularly when you've got ancestors moving between parishes as well. So something else to bear in mind. And of course, because they're just lists of names, not particularly difficult to try and interpret or find your way around those records. And they tend to be quite well preserved as well. Other types of record include notes of jury oaths, formularies of wording to be used when the manor courts are being opened and closed, and even records of court expenses. Court at Hulse, which was held in October 1773. And it records that 8 shillings were spent on beef and mutton, 1 shilling and 6 on bread, 1 shilling and 4 on nuts, 3 shillings on puddings, but all these sums are dwarfed by the princely 19 shillings they chose to spend on beer. So you do wonder what state they were in by the time the court closed, really, don't you? Perhaps they waited till after, who knows. Just to illustrate just how strangely bizarre these records associated with the manor courts can become, I did find in a court book of 1971 for one of Somerset's many rectory manors a very strange note, sort of pasted in on the title page. Just to explain rectory manors, they were a type of manor and they're particularly common in Somerset actually. And they would be owned by the successive incumbents in the parish. So you would have one rector, he would be the lord of that manor as long as he was rector. As soon as the successor arrives, he becomes the lord of that manor. And you don't tend to find them in many parts of the country. Hardly find any in Devon, but Somerset's got lots, at least 30, I think, off the top of my head, so quite a high number. But in one particular rectory manor, Curland, they granted leases in 1922, and the leases were valid till the last survivor among the parties to the lease was alive. And in 1971, they suddenly took a look at these leases, and of course, in most cases, the actual tenants had died, but the leases had passed on to their children. And there was actually only one survivor of all the parties, and that was the patron of the rectory in 1922. And the patron of the rectory was the Duke of Cornwall, who was also the Prince of Wales, and that's the future Edward VIII. And in 1971, they realised that he was getting on a bit, and he'd had health scares, and in fact, he died in 1972. So it was remarkably prescient, and they thought, hang on, we're going to have to do something about this. We haven't held a manor court since the 1920s, but we're going to have to appoint officials so that we can hold a court in the event of his death, so that we can renew these leases, etc. So anyway, stewards were appointed, and this was regarded as and other officials were appointed, and it was regarded as such an unusual event. It received a fair bit of publicity in the Bath and Wells Diocesan News. And then a few weeks later, the editor of the Diocesan News received a letter from a clergyman who knew the lord of the manor, the clergyman who was lord of the manor of Curland. And he wrote as follows. He said, "I'm glad that you were able to find room in the January news to announce the appointments of the Lord of the Manor of the appointments by the Lord of the Manor of Curland. I would suggest that the best way in which Messrs. Peters and Parks, that's the steward and deputy steward who'd just been appointed, could serve their new master would be to bring a lunch hamper to the next meeting of the Diocesan Synod. His lordship has a propensity to leave at home the packets of sandwiches that his wife so thoughtfully provides on these occasions. And he claims that the eating out places in the city of Wells cannot support him in the manner of life to which he is accustomed." So, that's just it's not technically a manorial record, but I'm just saying these are the sort of bizarre things that you can find bound up with manorial records. I think it's one of the strangest records I've ever come across anyway. Other types of records, aside from the court records, let's look at some of those for a minute. Crucial records are manorial accounts. They're things that are kept by officials like the reeves, the beadles, and the bailiffs, and they're described in Latin as compoti. How useful the early ones are for family historians, I would say doubtful. You get the odd tenant referred to, but essentially it's really about expenditure, rents and profits and things like that. It's dealing with things in quite general terms. It's talking about crops rather than people, to use a generalisation. Of far more value are things like rentals and rent rolls. They, in a sense, act as a valuable substitute for censuses in the pre-census age. Because again, you're getting lists of tenants and their holdings. Other particularly types of valuable record, I think, for family historians are manorial surveys. These are really wonderful documents they can be arranged in various ways. Some of them are arranged alphabetically by tenant. Some are arranged topographically, so they will follow the order of properties around. Now, if you trace your ancestor back to a particular village, say, in the 17th century, that hasn't changed much, and most of the properties are still there, if you've got a survey with a topographical arrangement, and there are other kinds of records that have survived from the same period, like maps, it might, in theory, be possible to work out which house your ancestor was living in, which most people just assume you can't really do unless it's a particularly grand house, in the sort of pre-19th century, because you think, well, how on earth can I find out? Surely it was just a cottage or something. And there's no records that can lead me to work out which property it was. But in theory, it's doable. I'm not saying that it's easy, but it's worth having a go. And if you find records like surveys surviving for a time when you know that your ancestor was living in a particular village, I think it's worth having a go, really, and seeing what you can find out. The particularly interesting thing about the surveys are that it gives you much more than names. It gives you details of the holding. It tells you how much it was worth, how much they're paying for it annually, how long they've been there for as well, and the terms on which they're holding it. So you can find out an awful lot about your ancestors' social status from that sort of record. Gives you a very good idea of, whether they're comfortably off, if they're not, when otherwise, really, the only other way to work out is whether there's a will or not. And of course, quite often, even quite well-off people didn't necessarily leave wills. So there aren't many sort of records out there for determining social status, but things like surveys really are among them. So if you find one, I think it's worth having a look, really. Other kinds of records, like I say, include maps. Now, of course, again, it's not necessarily immediately the sort of resource that a family historian might turn to, but in some cases you will find that when you order up a map of the manor, it shows the holdings of each tenant on the map, and you'll get the tenants' names on there. So never disregard things like maps. There's never only one type of map. It's always worth taking a look, but you never quite know how much it's going to tell you when you see it. So I would always think about looking at maps. And there are other sort of miscellaneous things, really. I don't really want to use the word ephemeral, because they're far too interesting to just be dismissed as ephemeral. But just to give you some sort of examples of the sheer variety of things that you can come across that were generated in the day-to-day affairs of the manor, I just want to sort of throw some examples of things at you that I've found in the last month, which I think just indicates just how valuable manorial records can be. So I'll just sort of fire through this list. So, Manor of Sandford Peveril in Devon, 1833. There's a letter from the steward to the lord of the manor informing him that the manor court jury have presented a particular outhouse to be removed as a nuisance. And you get details of the tenant, how long he's been there for, and all that kind of thing. That happens to be your ancestor. You've really struck gold if you find something like that. Another interesting thing I found recently, Manor of Honiton. These are all Devon manors. As I say, this is material I found recently while working at Devon Heritage Centre. There's an early 19th century list of deceased tenants. And one entry that particularly leapt out at me was one for a John Churchley. And he'd leased his tenement on the 30th of July, 1785. This is what it revealed. And it also revealed that he'd been buried at Kidderminster in Worcestershire on the 8th of March, 1828. Now, Kidderminster is in Worcestershire. It's actually where I come from, and Kidderminster's a carpet town. Honiton is near Axminster, which was a great textile centre. It's fairly clear that he was a carpet worker who decided to move north to Kidderminster looking for work. But let's say, you're John Churchley's descendant and you're living in Kidderminster. You may not know initially where he came from or anything like that. He died in 1828, so it's before civil registration, it's before the age of censuses. Okay, the parish registers might help, but how can you be certain it's the same John Churchley? If you come across something like this, it tells you everything that you need to know to be certain that the John Churchley from Honiton was the John Churchley who was buried in Kidderminster in 1828. I don't think there were many other kinds of records out there at the time that you could get that sort of information from, really. So, again, I think that's a clear example of just how crucial manorial records can be for family historians if you're willing to persist with them and spend a lot of time looking through them. As I say, it's never easy to find this material, but the thing is, the stuff is out there. Some other interesting things. This was quite a bizarre one. Manor of Downhumfreville in Axmouth. In 1724, there were various legal papers generated concerning the theft of rocks by the inhabitants of Lyme Regis, which is just over the border in Dorset. They needed the rocks to reinforce their harbour wall, and they thought, rather than pinching it from our neighbours in Dorset, that's going to cause some trouble. Let's go over the border into Devon, and perhaps no one will notice. Obviously, it didn't work, but it was worth a shot, I suppose. Another very bizarre set of records, 1709, from Manor of Axminster. Various papers concerning the right of the lord of the manor to a horse that had killed a man and that had been seized by the bailiff. And there's a huge amount of material about the horse being, the lord being entitled to this particular horse. They're far more concerned about that than they are about the poor chap who'd been killed. But it's a fascinating series of records. And again, 18th century, so you don't need to worry whether you've got Latin or not. They're quite easy to read. Okay, so the manorial system declined eventually, as we all know, because it's not here now. Really, it began to fall into decline pretty early, really. In the 17th century, and there are a range of factors that led to its decline. There was no catastrophic event that killed the manorial system. Essentially, you just had a gradual disintegration over time, and it was evolution rather than revolution, and a number of factors came together at around the same time, and yes, it had this sort of generally catastrophic effect on the manorial system, but a very gradual one. So there are a number of factors. You've got the appropriation of functions that have traditionally been overseen by the manor, by the parish vestry and township meetings, and also the quarter sessions, who often chose to ignore manor's claims over highways and bridges. But if you're a lord of the manor who's not interested in the status you have from being a lord of the manor, you just want to make money from it, actually, the fact that other people have suddenly decided that the highways and bridges are their problem rather than yours, it may not be so bad a thing. So quite often they're happy for these functions to be appropriated by other bodies. You've also got the general conversion of copyhold land to freehold land. Now, a crucial manorial, that's it. So generally over time, the manor's getting smaller and smaller. Because the Lord is working out, actually, in order to make money, I'm having to wait for tenants to die. And in some cases, you've got whole families who stay on for years and years and years. And he sort of thinks, well, hang on, I might get a heavier payment when someone dies. Actually, I'm going to make far more money if I just sell this land to the tenant and put it in my pockets now rather than waiting for him or her to die. So they decide to start selling it. And the whole manors end up starting to be broken up and sold, particularly in the 18th century. And certainly by the time courts are being held in the 19th century, you've got fewer and fewer tenants, so you don't need to hold the courts as often. You're not really dealing with local justice anymore, because other bodies are dealing with that. So you hardly ever need to hold a court, really. You only need to hold a court when a tenancy change is taking place, if a tenant dies or a tenant decides that they wish to pass the land on. And certainly by the 19th century, it's very typical for a manor court to have simply been held in a solicitor's office, and you have the minutes of the court in session. But we've gone from the grand manor court that's being held in the Great Hall or the courthouse of the manor house to actually being something that's just in a provincial solicitor's office, and the solicitor is acting as the steward of the manor. He's been appointed by the Lord, and the only other two people there are the two tenants who are undertaking the property transaction, the person who's getting rid of the property and the person who's taking it on. And then at the end, the solicitor, in his capacity of steward, writes, thus ends the court. And that was it. So that's a manor court, and it still counts as a court. But there you see how far the system had altered over time, and how it simply has become a utilitarian way of changing properties, when of course 600 years before it was an absolutely central feature of local justice, of village life and everything else. But of course, if you're a family historian, even those records that have been generated by 19th century solicitors are still enormously valuable, giving you the names of the person, his occupation, size of the property, how much the property is worth, etc., etc. So by the early 20th century, where manor courts are still being held, they've really declined to such an extent that they almost have become an object of ridicule in some cases. And some people see the manor courts as something where you've just got pompous civic dignitaries who are emphasising their authority by holding a manor court. I've even found some satirical manor court minutes which were anonymous, dating from 1919, which I think it's worth reading you an extract from, because this person really had a go at the various local officials who were running the Sidmouth Manor Court. So he writes, these are supposedly minutes from the court in session, and he calls it the Manor Court, but technically it's sort of a court of survey, because they seem to be going around the manor, exploring its various features. So this is an extract from it. He said, "We then visited the Victoria Hotel and found a great improvement in the electric light at the entrance. The manager, Mr. Maguire, cordially invited us into the billiards room and expressed his pleasure at once more receiving a visit from us. He offered refreshments and cigars, which were greatly appreciated. And then, at the invitation of the foreman, the jury and officials heartily drank the health of Mr. and Mrs. Maguire and success to the hotel. And as it was then raining heavily, it was suggested that a game of billiards would pass the time away, and several of the jury occupied the tables, special skill being exhibited by Wayward and Tedbury, who made some wonderful breaks, and who would have made more if there had been pockets all around the table, instead of only in the usual places." But the manorial system, which had declined so far by 1919 when this was written, survived technically until 1922, was when, as I'm sure Liz told you earlier, the Law of Property Act finally abolished copyhold tenure. But there are still parts of the country where, even though copyhold doesn't exist, you still have leases that were granted by manors. So, for example, in Curland, as I was saying earlier, where manor courts are still held. I think Yorkshire, I think, in particular, there are still quite a few manor courts that are held. So this system does survive in certain places, and it's not merely fulfilling a ceremonial function. There are places where you'll struggle to find them, but they are out there. Whether you'd want to live in an area where you have to attend a manor court twice a year, I don't know, really. I would have thought it affects property prices, to be honest, but who knows? So I'm going to now spend some time talking about my own work, what I do on a day-to-day basis, what the job involves, the kind of records that I see, and really how the register can benefit you in your research. So as Liz would have outlined earlier, the original MDR exists in the form of handwritten paper slips, and they're arranged by county, and then parish, and then manor. Alphabetical arrangement by parish, and then within each parish all the manors are arranged alphabetically. Well, that's in theory. I mean, the state of some of the original card indexes in the MDR, you're lucky if they're in the right county in some cases. Generally, it's not too bad for an old 1920s paper index. In the case of Somerset, there are 10 volumes of these slips. In the case of Devon, there are 16 volumes of these original slips. And the whole purpose of my project has been to check the information on these slips, evaluate, correct, and revise and expand as appropriate for inclusion in the new electronic MDR, which Liz will have shown you earlier. Now, you see the benefits of this from the statistics from the Somerset project, which, as I say, was completed in December last year. It's now significantly larger. The original paper manorial documents register contained approximately 400 manors and had approximately 4,500 record entries. The revised manorial documents register contains 844 manors and over 12,500 record entries. So there's a very immediate benefit. It's far more comprehensive. I'm not claiming that it's fully comprehensive, because I'm still finding material for Somerset now in Devon. It's an unending process, I think, in a sense. But the beauty of it is, once you've got it in an electronic format, it's so easy to revise, to add to correct. And I'm sure researchers will find mistakes as they work through it. But because it's electronic, it's not like dealing with a cumbersome card index. Someone finds that a date is wrong for one of the court rolls, well, fine. Send that information into the National Archives and it can be changed very quickly. So it's something that's constantly being revised and added to and updated. And of course, it's far more accessible than your old-fashioned paper index as well. And of course, the other key thing is, unlike an archival catalogue, which deals with material held in a particular repository, it's bringing all the records for a particular manor under the heading of that manor, irrespective of where they're held in this country, irrespective of where they're held in the world. So in a sense, it's almost better than an archival catalogue, because if you're interested in a particular manor, rather than having to go through various catalogues in different record offices where you think there might be material, this has already done that for you. It's brought all that information together. There's a huge variety of records that appear in the MDR, as I hope you've sort of gathered from my talk, and as I'm sure Liz showed you earlier. And the chronological variety is pretty astonishing as well. The earliest record on the Somerset MDR is an account held at Longleat House for manors owned by Glastonbury Abbey, and that's dated 1257 to 1258. And the latest record is a court book from 1972. So you've got essentially 700 years worth of records on there. Also worth bearing in mind, of course, that for some manors, particularly those owned by the ecclesiastical authorities, you will have a continuous run, or almost completely continuous, of all sorts of manorial records, accounts, court rolls, etc., right through from the 13th century to the early 20th century. So you've got an incredibly valuable resource as a family historian if it turns out your ancestors lived for a long time in a place like that. The problem is, of course, for the survival rates vary considerably. And it's got an awful lot to do with the vicissitudes a particular family was subjected to. So you may well find for some manors that were just as important as other manors There might just be a handful of records that have survived across 700 years, or there may be no records that have survived at all. We know it was a manor, for example, because we've got deeds stretching over several hundred years where it's described as a manor. We may well have other kind of deeds where, for tenants, where they have to perform obligations to the lord. So we know that it was a manor, and we know that courts were being held at some point, but no actual manorial records have survived. You tend to find that manors owned by the ecclesiastical authorities have the highest survival rate, because they tended to own them from the year dot right through until the 19th century, when they surrendered their estates to the ecclesiastical commissioners, and all those records never had to move, because they would have been kept in a muniments room at the cathedral, etc., etc., never had to move, so the survival rate's been very high. The more times a manor has changed hands, it's like everything else. The more families that something passes through, the more likely things are to get lost along the way. So if a manor has changed hands multiple times over the centuries, it's far more likely that at some point someone decided to chuck the medieval stuff on a skip. Like most things, the reasons why things survive is through laziness. Because actually, if you own a manor, if a single body owns a manor for 600-700 years, they never have to send the records on to anyone else. They just keep them there in a room. They may not ever bother to look at them, but far easier just to leave them there than ever bother to clear the room out. If you're selling it, you have to clear the room out, and that's when stuff gets chucked. So the safest thing that could ever happen to manorial records is that nobody bothered to look at them for years. Then they tended to survive far more effectively. Now, of course, much of my work involves checking the original records, and this sort of has a number. This is done for a number of reasons, and it has a number of knock-on effects. So, for example, I need to establish standard manor names for manors that have multiple aliases. Often you find a manor might have had 3 or 4 names. Sometimes you find several manors in the same parish, which were separate manors throughout their history, but which all have the same name. That can be very confusing, as I'm sure you can imagine. Also, I need to look at records sometimes to decide whether a supposed manor in fact really existed. There are an awful lot of entries on the original MDR which claim to be for manors, but often they're just districts of 100, which is a bigger area composed of multiple manors and other estates. And sometimes a place is referred to in the margin of 100 roll, and you think, oh, it must be, and someone's looked at it in the 20s and said, oh, well, it's probably a manor, and they've put it on the original MDR. But actually, it turns out that it isn't a manor. There are also cases where often it's simply a matter of me updating references for recatalogued records and updating details of records that have changed location. So, for example, a lot of records in the 1920s would still have been in private hands, but a huge number of those records are now in public repositories, local record offices, etc., etc. So often in the original MDR it might say court rolls for the manor of X with Mr. So-and-so at something house. They're now at Devon County Record Office or Somerset County Record Office, etc. There are also sad cases where records that have been listed on the original register in the 20s have been lost or destroyed in the last 70 or so years. So, for example, the manor of Chew Stoke in Somerset in 1926, the Historical Manuscripts Commission who oversaw the MDR were informed that there were court rolls for that particular manor, and they were still at the manor house. They hadn't come to Somerset Heritage Centre at any point, and I spoke to Mary Sirrow, who's the editor of the Somerset Victoria County History, and she'd gone to Chewstoke to try and track them down 20 years ago or so, and she was told unfortunately they ended up in the skip long ago. So there are losses like that are quite rare, fortunately, but it does still happen. I think really because now we've got an electronic register, because people are far more aware of the MDR, it's far less likely now that things like that will happen. These were the kind of things that may well have been more common in, say, the 50s or 60s. I would hope that they're far less common now. Particularly, I think now, even if you don't have any interest in history whatsoever, even if you don't know anything about manorial records or anything else, I would have thought now if you open a box and find something that's clearly very, very old, you will attempt to find out what it is, and you will at least think this clearly has some worth. It's not a matter of simply, chucking it out. So I spent a lot of my time actually checking catalogues and for repositories beyond Somerset and Devon. And where necessary, I visit those repositories in order to check the original records. There is material, for example, at the Huntington Library in California. I haven't had the privilege to go there, alas. But never mind. But Dorset is easier to get to, so sometimes I go to Dorset History Centre instead. So there are various out-of-county repositories where Somerset records are held. In fact, Somerset manorial records, believe it or not, are to be found at over 30 locations outside of Somerset. And they range from Alnwick Castle to record offices in places like Yorkshire and Sussex, cathedral libraries in Winchester and Worcester, and also such institutions as St George's Chapel in Windsor and various Oxbridge colleges, including Balliol, Oriel and Corpus Christi. Often, these records are mentioned in the original MDR, so then it's simply a matter of going to those catalogues. At other stages, my research on the history of a manor has led me to realise that it was in the hands of a particular family at one point who deposited records in, say, a record office in Yorkshire or Sussex or wherever. And then I will think, well, hang on, maybe there is some material on those manors there. And then it's a matter of checking the catalogues, making inquiries. So sometimes guesswork is involved, educated guesses. And sometimes serendipity as well. There's a manor in North Somerset on the Gloucestershire border called Swainswick. And nothing about it at all in the original manorial documents register, not the slightest reference. And so I'd never come across it as a manor. Nobody had ever mentioned it to me. It wasn't a name that meant anything to me. Then I came across it in Kelly's Directory from 1896 when I was looking for details of another manor. And it described it as a manor and said that it was owned by Oriel College, Oxford. And I thought, well, let's just see if there is anything. So I got in touch with the librarian at Oriel, not really expecting much. I didn't really expect there to be anything that had survived, because I thought, well, surely it will be on the original register if there's a decent survival of records from held at an Oxford college. And much to my surprise, he got back in touch and said, oh yes, we've got 400 years worth of manor court rolls, accounts, maps, surveys, rentals, you name it. And this wasn't reflected on the original register at all. So really, a lot of the work involves dogged persistence. And I think luck plays a part as well, particularly when you're dealing with so many manors and so many records. Yes, chance does play a part from time to time. When it comes to Devon records, they're just as scattered as those that are held at National Archives, as those that are held in Somerset. So you will find that there's material at the National Archives just as there is for Somerset, British Library just as there is for Somerset. But they're also distributed across various other repositories. So in Devon's case, there's material at West Sussex Record Office, Lancashire Record Office, Warwickshire Record Office, Essex Record Office, Durham and Nottingham universities, even the Shakespeare Birthplace Trust in Stratford-upon-Avon. King's College, Cambridge has a particularly fine collection of manorial records for the manor of St James's Priory in Poleslow, which is one of the Exeter suburbs. Beautifully catalogued, and yeah, a great run of records just for one manor extending over 600 or 700 years, and the catalogue for it runs to 50-odd pages, and that's just one manor with records in one place. So you do tend to find, as I was saying earlier, if there's a particularly prestigious sort of owner, if it's the church, if it's the crown, you're far more likely to have a much better survival of records. And of course, if you've got crown ownership, then you're very lucky, because you'll have a very full collection at the National Archives, which probably has the best collection of manorial records in the country. The British Library has a reasonable amount of material, but it tends to be things that have been donated by antiquarians over the years, so it's much more of a hit and miss, really. They do have a lot of material there. It's not necessarily the easiest of material to access, particularly as the original British Library catalogues aren't that easy to use, either in terms, I don't know if anyone ever has tried to use them, but the original volumes aren't that easy. Most of the Manor Court records appear in these wonderful collections, sort of ad charters and ad rolls, ad standing for additional. They've also got an online catalogue now, which I don't find particularly easy to use, to be honest. TNA, the National Archives, you're in much better luck, because Discovery is a sort of all-embracing, holistic catalogue now, and the Manorial Documents Register itself is part of it. So it should throw up results for material on the register, but also for material that's held at the National Archives, that appears in the National Archives' own catalogues, which are often will be much more detailed than the MDR entry. Because, of course, in my case, where there's a run of court rolls, a consecutive run, I say how many there are and give the start date and the end date. The original catalogue at the National Archives will break those entries down into individual years and give you details which particular year of the actual individual years that the individual reference numbers relate to. So if you're interested in a narrower period, I would use the National Archives catalogue in addition to the MDR. The MDR, I think, is a great signposting resource. I would always go and look at the other catalogues as well, because often, especially the MDR is just giving you entries like court rolls and accounts. You will find that a lot of local record offices, their individual catalogues for manorial records, when they're in state collections and such like, they will go down to much more detail often. They will give you the names of the lord within the catalogue, possibly even the names of some of the tenants, and even some of the business being transacted at the manor court. Right, now when it comes to actually using manorial records, can I have a show of hands of people who've actually used manorial records? That's pretty good, actually. That's pretty good. I asked the same question when I was giving a talk on Monday, and there were about 50-odd people there, and it was the Friends of Devon Archives, so I expected a big show of hands, and I was rather horrified when only 2 people put their hands up. So you're doing very well, I have to say. A lot of people, I think, do find them difficult to use, particularly as they were officially to be kept in Latin until 1733, although a lot of earlier ones are already in English. Some of you may have found. Of course, the handwriting is challenging as well. But on the plus side, even when it comes to early manorial records, they are quite formulaic. So once the handwriting's been deciphered, even if you don't know Latin, you can work out what's going on by comparing it with a huge number of published sources for manorial records. And there are an awful lot of them out there. There are great transcripts for manorial records available online which cover a huge variety of them. So the Conisbrough court rolls in Yorkshire, they can be accessed online, and that's a very good resource. Printed transcripts, so for example Hale's Owen in Worcestershire, their court rolls were translated and transcribed, and you can access those online as well. So what I'm saying is, even if you're not that comfortable looking at Latin documents, if you take your original court roll, compare it with a transcript, and then look at the translation with that transcript, I think you can start to get somewhere, particularly when you're looking for names within them as well. Because obviously names are names at the end of the day, whether they're in a Latin document or an English document. The other thing to bear in mind as well, I think, is that Google has really revolutionized a lot of research into all kinds of records, and I'm not sure that we're always sort of in the research community. I don't think we're aware necessarily how beneficial just the internet can be generally. Certainly when I come across tricky Latin phrases in court rolls that I've never come across before and I can't work out what's going on, and I think, well, I can't work it out, I haven't seen it before, it must be something unusual, so it's probably something interesting. What I tend to do is go on something like Google Advanced. I don't know if anyone uses that. Type in the exact Latin phrase, and it doesn't always happen, but hey presto, you find some obscure website, an American academic out in the Midwest or something at a university you've never heard of, and he's come across a phrase just like it, and he's attempted to work out what it is and offered some theories. So there are some really wonderful online resources out there. So it's always worth, if you do come across something tricky, do type it in online and see what comes up, because you never quite know really. And of course the other thing to bear in mind, even if you've got no Latin, is that, as I say, there are an awful lot of manor courts that were still being held even in the early 20th century. So even if you're not comfortable with using Latin documents, you've got 200 years worth of records post the early 1700s that will be in English. And they're no more difficult to look at than lunatic asylum registers or workhouse admission registers or parish registers. In some cases, often I find manorial records from the 19th century, the handwriting is much easier to read on those than, say, in copperplate handwriting in a lunatic asylum admission register or something like that. And sometimes when you look at Victorian handwriting, where there's page after page of it in a volume, it can be very hard work. Sometimes it's easier to try and read 18th century stuff than Victorian material. So I think what I'm saying really is, if you haven't used them before, don't be frightened of them. I think people always say how terrifying they are. People told me how terrifying they are before I started to work with them. I think people were trying to put me off from going into this sort of field. But they're never quite as scary as you think they're going to be. And like everything else, with practice, with time, with perseverance, you gradually become far more comfortable with them. And as I hope I've sort of illustrated to you, you know, the whole purpose of my talk really is, you know, to try and convince you to use these records, which have historically been chronically underused. Although hopefully with an online register available, that situation is now changing. Because I think one of the difficulties in the past has been difficulty of access. They're often not properly catalogued. They're often buried in estate collections. The register now in its electronic format is sort of throwing these records open and making them much more accessible. I think, yes, really, it is, you know, persevere and have a go with them, because you'll find some absolute treasures in there. There are some real gems. I think that's pretty much all I've got to say, but I'm more than happy to take questions. I think we've got 10 minutes, yeah?
Do you think he's achieved his aim of trying to get us to use them? I think he has. That was absolutely super. Are there any questions from anybody, please?
Just a very quick question. Commonwealth period.
Yeah.
Now, one of the big gaps in family history, and that'll be the same for one-name studies, is the survival of records for the Commonwealth period. In another county, Wiltshire, I found evidence where there was no manor court records survive, and maybe there wasn't a manor court being held during the Commonwealth, but post the Commonwealth, there was kind of a mopping up operation to establish who was who and who was owning what and who'd owned it and who'd therefore died during the Cromwellian period. And I wondered if you'd found similar things, or maybe they hadn't been. I guess it's whether there's a pattern anywhere in Devon or in Somerset.
So so the sort of things you found presumably were surveys and things like that, or were they courts being held that specifically discussed who died in the intervening period, or something like that?
It was a kind of a mop-up. So and it was in English, so it was in the Restoration.
Right.
You know, it wasn't in the catalogue. It's nothing. Not noted
nothing is specifically identified.
Nothing special. But the actual record itself, when you got into it, it wasn't a huge number of pages, but it gave this had moved to this person and this date and that date. Anyway.
So what was it actually described as a survey, or?
Well, I was going through all the manorial court records that survived a certain period. So it just sat within in the sequence, and there was nothing for a period, and all of a sudden this cropped up.
It re-emerges. It must have been something to do with local circumstances. I mean, perhaps the Lord of the Manor had been killed in the Civil War or something like that, but certainly I can't say I've seen any pattern like that. I mean, what you tend to find is that manorial records, where you've got a good survival rate, obviously where you haven't got a good survival rate, it's impossible to extrapolate any pattern anyway, but where there's a good survival rate, you tend to find them continuing uninterrupted during the Commonwealth. In fact, Commonwealth manorial records tend to be easier to deal with, because they tend to be in English for a start, and then they will revert back to Latin on the Restoration. And of course, they're easier to date as well, because you'll get the calendar year as opposed to the regnal year, you know, 5th year of Charles I or whatever. So no, I haven't seen a pattern like that. So that's an interesting find. I wonder if, because I know Virginia Bainbridge, who is revising the Wiltshire Register, because that's an ongoing project. I mean, I wonder if she is aware of that. That's. Yeah, I think that's something she'd be quite interested in. I certainly haven't come across anything like that myself within manor court records or surveys either. I mean, as I say, you tend to find where there's a good survival rate, they will continue uninterrupted through the Commonwealth anyway. Often it's very interesting, because the interesting thing is, I think when you look at parish registers during the Commonwealth period, there's a sense that this is England in an age of crisis, even after the Civil War, but you still get skirmishes and things like that referred to, don't you? But in manor court records, it tends to be business as usual, to be quite honest. I've never noticed any sort of catastrophe. But on the other hand, they're chronically under-investigated, manorial records, by academic historians for that period. The trouble is, medievalists know a huge amount about manor court records, but a lot of Tudor and Stuart historians just assume that there isn't going to be much for them. But I think that situation is changing now. I was talking to someone at work a couple of weeks ago from Exeter University who's interested in 17th century social history, and he said historians are now beginning to look at manor court records from that period, when before they'd really ignored them, to try and, see what they can tell them about that period. I mean, the interesting thing is, if you look at a book on, history of the plague in England, for the Black Death, they've used manor court records repeatedly to look at tendency changes. But hang on, what about the plague in the 1660s? Nobody bothers to look at manor court records to find out what that's telling them about, what they're telling them about, pestilence, etc. But I think the situation's changed now. But that's a very interesting find. I'm glad you've raised that. I think that is something quite unusual.
My question is much more straightforward. Were the 3 life leases ever in manor court records, or is that something that...
No, in some cases, yes, because there's the manor court didn't only deal with copyhold land, it often dealt with leasehold land as well. The Curland manor court records I was discussing earlier from the 1970s, they were 3 life leases.
Who benefited most, the landlord or the tenant?
In tenancies generally?
No, in the 3 life leases. I mean, what were their benefit for?
I'd say, well, the landlord would have benefited to some extent. It's a pretty good deal for the tenant as well. I think they both did quite well out of it, really. Not a bad deal, I don't think. It could have been worse.
Okay.
I was interested in what you said about Somerset. I think you said after the end of what you'd done, you'd virtually doubled the number of manors in Somerset. I don't know whether this is found similarly in other parts of the country, or was it just Somerset? I mean, obviously other people...
No, what you tend to find with the revision is that because a concerted amount of time has been devoted to it, when with the original register, it was just whether people happened to notify the HMC in London when they came across material in their research. Because it's a specific project, with a dedicated amount of time to it, you tend to find that the numbers go up significantly. That's really one of the things that justifies the project the most, that you end up with something far larger. It's not just transferring data from a paper format to an electronic format. It's much more than that. It's all essentially a whole new register, really, that's far more comprehensive and varied in what it details.
So we can look forward to finding something similar in Devon.
I suspect there'll be a very large number of Devon manors ultimately, more than 1,000, I think. Yeah, it's a big county.
Any more questions from anybody? Well, I think it just remains for me to say thank you very much indeed for an absolutely fascinating and informative talk, and I think you've probably encouraged all of us to go rushing back and see what we can find, and see where it takes us. So thank you very much indeed, Scott, for coming to us.
Thank you for inviting me.